Buenas tardes, chicas. Mi nombre es Mariano. En unos 5 minutos vamos a estar arrancando con la clase que dio más temprano Mike Waters. ¿Me pueden confirmar si ven? em, Estoy compartiendo una pantalla, si la pueden ver.
Hola, buenas tardes. Sí, sí, se ve.
Excelente, muchas gracias, Anaí. En 5 minutos arrancamos. Igual les aviso en cuanto arrancamos, ¿sí? Gracias.
Bien, gracias.
Hola,
Buenas tardes, chicas, para las que se sumaron recién. Mi nombre es Mariano. En 5 minutos vamos a estar arrancando con la clase que dio Mike hoy más temprano, ¿sí? Gracias.
look at me. Fresh out of the people lake. Just eat your dinner. Are you gonna find out the sex? Yeah. No? I want to be surprised. I don't like surprises. What about baby shower? People are gonna want to know. Oh yeah. We got a baby shower. Baby shower. Okay. you know the modern baby shower has history of ancient Egyptian and Greek civilizations? So, well, show up for a while. Where's George? Open up. I said, go away. Don't get us in. Tom here says go, lock the door now.
Ale, tenés el micrófono abierto, me parece.
Buenas tardes, chicas. No sé, creo que no me escucharon. Esta tarde Mike estuvo dando una masterclass. Yo les voy a dejar la clase para que la puedan ver. Recuerden todas las dudas que tengan. Nos escriben al Lex y nosotros se las vamos a hacer llegar a Mike. Y la semana que viene creo que va a seguir Mike también. Así que cualquier cosa, por favor, escríbanos. Y yo los dejo con la masterclass que dio Mike. Y Alejandra, tenés el micrófono abierto, ¿sí? Que tengan
Sí.
linda clase, chicas.
Gracias. Una consulta.
Claro.
¿Tenés porque por ahí creo que no se dio cuenta. ¿Podrías silenciarla, por favor? Para que no se escuchen las dos, por favor. Gracias.
No, por favor, ya la silencio. Gracias, chicas.
Gracias.
Gracias.
No, por favor.
Wait, buddy. No, I know it seems bad now, but you did.
Finally, spring arrived a month late. It should have arrived here in March, but it didn't. We had a horrible winter, very cold and grey and yucky, wet, snowy, everything. But it finally arrived, but it's kind of chilly again today. But the weekend I did garden. I'm a big fan of gardening, so I spent the weekend working in my garden. I knew nothing about gardening until the pandemic. When the pandemic came and I was stuck in, I thought, well, the only outdoor place that I can realistically go is my own garden. So that was it. So,
with the pandemics, we learned so many different things, right? So crazy.
Oh, online learning being chief
Yes.
among them. The pandemic actually revolutionized the world in so many ways. But yeah, but what you were saying there, yes, whenever I go anywhere and I'm renting a car, my big worry is that something will happen with my license or credit card or something, and they'll tell me, sorry, you cannot rent a car. That's always my big fear, and that I will be carless for the trip. I see two people now have, one person left.
Yes, they're little by little they are arriving, okay? And I have another
Good morning, good afternoon.
Hello.
Pepo.
Okay.
I'm going to send a message to.
Good morning.
Hello, Paula, is that right?
Yes, hi.
Hi,
Mike.
Paula. Nice to meet you. I'm Mike. You're very welcome.
Nice to meet you too. Thank you.
I'm trying to
We
admit
were-
Bernie.
Yeah, sorry, Natalia.
No, I'm trying to admit one of the girls. Because I can't admit to one of them, which is Bernie. She's joining us, but she can't do it. Hey, Bernie, so you finally appeared there. I was looking for you because it said I was not admitting, and I continued to try and have you inside, okay?
Yeah, thank you.
So there is, so this is Mike Waters. Mike, would you like to introduce yourself, girls? We are waiting for more people, but we'll have like a couple of more minutes waiting, and then we're starting. Okay, Mike?
Okay. Okay. I'm Mike Waters. I'm a lawyer. Well, I'm qualified as a lawyer, but not practicing at the moment, from Ireland. But I now live in Romania. My wife is from here, so I'm based full-time in Bucharest. And like I say, I'm a qualified lawyer, and my specialization is legal English. I also do business English, business writing, technical English, and a few other areas of ESP as well. I run a small training company here in Bucharest along with my wife, and we deal with a variety of clients. My wife deals more with teenagers and some general English courses, whereas I do all the more corporate and legal stuff, like business English, English for banking and finance, and of course legal English. For me, it's the ideal job because it combines my love of teaching and training with my love of the law as well. And also it ties in with my growing interest in technology and AI and the potential that AI offers without being unaware of the dangers presented by AI as well. But that's a whole other discussion. So basically that's me. And in my spare time, I mess around with my computer, making lots of mistakes. I like cooking. I like socializing with friends and sharing what I cook and some nice wine. And down there in Argentina, I must say, you've got some fantastic wines. You're quite famous for your wines. You claim to have the best beef in the world, but we Irish say that we have the best beef in the world. So we'll declare a tie on that one.
Okay.
You have fantastic beef down there for sure.
Yeah.
But when it comes to wines, you guys beat us Irish hands down. In fact, we Irish don't have wines. Not enough sunshine for wines. But you guys do great wines down there. And I like travel, but I've never been to Argentina. I've been to Brazil.
You should come whenever possible.
Yeah, I think I'd really enjoy Argentina. I think from a cultural point of view, Argentina is probably more interesting, although Brazil was interesting as well. But from an arts and culture point of view, I believe that Buenos Aires is a great city. And when I go there, I've got to try lots of, in fact, churrascarias and drink a lot of your great wine.
For sure.
So at some point, I hope to make it down there, for sure. It's yeah, and I believe as well, you've a perfect climate down there as well. Unlike Brazil, which I found. In Brazil, I liked the heat, but not the humidity. The humidity was uncomfortable, to say the least. Okay, so should I start or should we wait another few minutes? What do you think of that? So very nice to meet you, Malvina, Bernadita, and Paula.
Nice to meet you, and thank you for your warm presentation.
Oh, well.
I would love to be in Ireland. I'm in New Jersey in the United States now, but
okay.
You know. Yeah.
Are you guys lawyers or translators, or are you a mixture?
I'm not a lawyer. I'm finishing my master's in translation and interpreting here in Rutgers University, but my background is business administration. So, but I'm very interested in this class because we have been so far. We have been able to see a wide range of vocabulary and new stuff for myself that I'm enjoying a lot. So I can't wait to hear your class today.
Oh, thank you very much. I hope I don't disappoint.
Of course not.
And Paula, what about you? Where are you? Are you in Argentina at the moment?
Yeah, I'm from Argentina. I'm in Buenos Aires at the moment, and I'm a sworn legal translator from the University of Buenos Aires. Right now, I'm working as a legal English trainer as well in LCT with Nati,
Okay.
and I'm also a paralegal for a personal injury law firm in California. So, but not a lawyer.
Okay. And what about you, Bernadita?
Well, I'm a certified or sworn translator based in Argentina. I'm born in Argentina and based in Buenos Aires. I am a retired university teacher, which means that I have worked for more than 35 years. I'm not that old. I'm only 71. At Buenos Aires University and several others. And I have worked as a freelance translator all my life, 44 years now. And I'm also an author and publisher of specific books for our profession, traducciones de contratos, English into Spanish and Spanish into English. Two books, of which the second one is in market since last Friday. That is 3 days ago. I brought it home, and well, I'm so happy.
Congratulations.
That's it.
Okay, thank you. And Carolina?
Oh, hello, I'm Carolina. I'm a sworn translator as well, based in Argentina. At present, I work for a IP law firm, working with the foreign clients and checking the documents they send, translating them, assisting the translators in the group, and reporting them and receiving their reports for Argentina. So this is my usual work today.
Okay. So you're all translators, yeah? Okay. Well, well, I'm not a translator. Sometimes I do some copy editing on works that have already been written in English, and I just correct the English and sort of knock it into shape, so to speak. I can't be a translator because the only languages at which I'm good enough are my own native language, English, and also Irish Gaelic, which is the joint official language of Ireland. It's actually the official language, but nobody on the street speaks Irish as a first language. Everybody in Ireland speaks English as a first language. The result of colonization, and this is a subject we'll touch on in my presentation, actually, and the effects of being part of the British Empire for 700 years. Okay, so I can only do English, so therefore I can never do translation. I don't think anybody wants anything translated into Irish outside of Ireland. I'd be very surprised if they did. It's a tiny minority who speak it.
Well, but sometimes they might need it into other languages. If you, for example, if they want to move abroad and maybe translate their diplomas, for example.
No, in Ireland, all official. Yeah, it's a kind of a strange situation because the official language of state is Irish, but all our state business, as well as private business, all our state business is done through English. English has been the majority language in Ireland since probably the late 19th century. Probably 1860s, 1870s. Well, it happened gradually, but I would say by 1900 it was complete. By 1900, most people in Ireland spoke English as a first language, except in some small enclaves of the country, some isolated areas. So I don't think anyone will be needing Irish, so I have to stick with English. So today I'm going to speak with you guys about the differences between the common law and what is generally referred to as civil law, but what is also referred to as Roman law. Now, I will, for the purposes of this talk, I'm going to refer to it as Roman law for two reasons. The main reason is that in English-speaking systems, when we talk about civil law, we're not so much talking about what you guys consider to be civil law. Rather, we are referring to any law that is not criminal. In other words, private law. So any law, so criminal law, of course, it's public law. It's the state versus the individual. Private law, it's individual versus individual, or individual companies and whatever. So we refer to that as civil law. So just to avoid any confusion in case the term civil law comes up in any other context, I'll refer to it as Roman law, but effectively I am referring to civil law. And the other reason is it was invented more or less by the Romans. We'll take a quick look at that as well. Have you everything running there to record, Natalia? Yeah. Are you recording? Oh, you
Yes,
are.
I'm
No,
already
are
recording.
you? You are recording. Okay. So I will let me share my screen. Okay, can you all see the screen? Okay.
Yes.
You can.
Yes.
Okay. Okay. So I'm going to be looking today at the differences between common law and Roman law or civil law. And they are two different legal systems, but they're not mutually exclusive. There is a lot of overlapping as well. Now, when you guys hear about common law, what do you think of when you hear about common law? You're all familiar with the expression, I'm sure. Common law. What does common law mean to you guys? Anyone like to answer? Any volunteers?
Well, the Anglo-Saxon system of law.
Yeah, very good. Yeah, that's basically it. The Anglo-Saxon system
with its own characteristics, very different from Roman or civil law.
It is. There are certain similarities too, but and there is more convergence, and there will be even more convergence in future. But historically, they have developed as two separate.
Getting nearer in times, right? They are nearer now than they were many years before.
I would say they are nearer now than they were even 50 years before, or 50 years ago. In the let's say in the 1960s, even in the 1970s, there were still two different systems. A number of developments a number of social and political developments have brought the two closer together, but we'll take a look at that towards the end. So, okay, so I'm going to throw out another question. If we look at the picture here of these two gentlemen, what do you notice about them?
Well, first of all, custom clothes and rigor, right?
Yeah.
I don't have the right word right now.
A wig. That's right. We call it's a wig and a gown.
Yeah.
And does anyone know what we refer to his profession as? The guy with the wig and the black gown. No, we call them barristers. And not in all common law systems, but in Britain and Ireland, in Australia and Canada and Australia, the barrister and the solicitor have two different roles. The barrister is the guy who goes into court. He is usually a specialist in some area of law. So if you have a personal injuries case, you will definitely hire a different barrister to the one you would hire if you had a commercial matter to deal with, for example. And the solicitor is more like the GP. When you have a legal problem, any legal issue, you would go to the solicitor in his office, and he's like your medical GP, the general practitioner, and he will give you more general advice in the office. His role is more of a consultant. And well, he also deals a lot with paperwork, a huge amount of it, more than in civil law systems. So the guy in the office, which could be the guy on the right, by the way, the solicitor. The guy in the wig is the barrister. He's the guy who goes into court, who presents your cases in court, who provides the more expert advice. He's the consultant, like a medical consultant, a medical specialist, I should say. And I don't think you have barristers in the Roman law system. I think it's just the lawyer. And in the US, the US is a common law system, but it has a large Roman law influence as well, which came from the French in the 18th century. And in America, they don't have solicitors and barristers, they just have lawyers. So when you hear the term lawyer, it covers solicitors and barristers in our system, but both solicitors and barristers are lawyers. So
excuse me, can I ask you one quick question?
Please, please.
Can a paralegal couldn't be compared as a solicitor, because here we have paralegal that, I know it's people that, study law, but they're not lawyers, but.
No, the paralegal still has to study. The paralegal is very often more of an expert than the solicitor. When I was doing my apprenticeship, my training period in a solicitor's office very many years ago, we had a paralegal in the office who handled all the property law matters. And he actually knew an awful lot more than the solicitor who owned the practice. It was a small one solicitor practice in a small town in Ireland, and the solicitor did everything. But our paralegal actually did all the property law matters, property and conveyancing, as we call property transactions. And he also did probate. And he knew a lot more about conveyancing and probate than the solicitor did. So very often the paralegal is more of an expert in specific areas than many solicitors, because the paralegal's role is confined to the office. The paralegal works in the office, whereas solicitors would go to court. The solicitors work in the lower courts. If you have like the magistrates court in UK or the district court in Ireland or the US, you wouldn't, well, the US is just the one anyway, but in Canada, let's say in Australia, in the district court, the lowest level of court, the solicitor would handle matters because they're quite general. But in courts, all higher courts, then the barristers do it.
Thank you for the clarification. Thanks.
Sorry?
Thank you for your clarification.
Okay. Now, you're most welcome. So, okay. Now, okay, as we've already seen, I've said here the world's legal systems, but not all the legal systems. We could say the Western world's legal systems are basically based on either the common law or the Roman law. And these different traditions, these two traditions, they differ in many areas, but the four main differences lie in the sources of law. This is a very important distinction, where the law comes from, where the laws come from, the actual rules. Legal reasoning, in other words, the thinking of judges and lawyers. Court and other procedures, such as real estate transactions, and contract interpretation. And the fourth one of those, contract interpretation, is actually related to the first two, sources of law and legal reasoning, as we will later see. So again, a knowledge of both systems helps lawyers and anyone working in the legal field, I think. Understanding both systems, whichever system you work in, understanding how the other works, I think, helps in areas like contract drafting, interpretation and translating, and for lawyers going into court, a litigation strategy, because, like I said, there are considerable differences in how the courts operate. And also understanding the intentions of legislators, the people who make laws. Should we interpret a law by what's written there, or should we interpret a law in the context of its time and what the legislators might have meant back then? And I will discuss an example with you later about that. Okay, so we see the countries where Roman law mostly exists. It exists. It's used in Romania, where I'm now living, in France, Germany, Italy, Spain, and down there in Argentina, in Brazil, and in Japan, which is not really the Western world in the way we might normally understand it, but they also use Roman law principles in Japan. Whereas in these countries here, among others, the common law prevails. The UK, US, Ireland, Canada, Australia, New Zealand, South Africa, you could say the big seven English, native English speaking countries, but also in India, Pakistan, Malaysia, and also in other countries where they have totally different legal systems. They use certain common law principles and some Roman law principles too. And one I'm thinking of here is Saudi Arabia. I lived in Saudi for about 8 years of my life, and working as a teacher and trainer there, not in the legal field. But Saudi Arabia, its legal system, as you probably know, is based on Sharia or Islamic law. But much of their modern law, especially in areas of commercial law, even road traffic law, company law, contracts, while they are essentially governed by Quranic principles, they borrow a lot of codified law, in other words, statutes, legislation, from the US. So you will see a lot of commercial law, especially in Saudi, and now a lot of environmental environmental and local laws are based on Western law, particularly the US. So there is greater convergence now than ever before. So let's take a quick look at the origins. We see here, in the top picture, we see a Roman emperor. Not necessarily Justinius, this is just a generic picture of a Roman emperor. Thanks, ChatGPT. But we see that it originated, of course, which is why we call it Roman law, of course. It originated in Rome. and was used in Europe, in most European countries, throughout the centuries, through the Napoleonic era. And in the 19th century, far more, as society became more complex, far more laws were written, were enacted and codified as statutes. And we see in the last picture here, just again, generic picture of a statute, Civil Code 1, 2, 3. Now, the common law system developed on rather different lines. As we know, the Normans came from France in 1066. They conquered Britain. In terms of law, not much happened in 1066. The laws didn't exactly change. Nobody said, we hereby declare that this law shall now be Roman law, or sorry, shall be Norman law. No, they didn't. Nothing like that happened. The laws continued up to around 1215, 1220. I'm not sure what year it was exactly, but in the early 13th century, we had, of course, Magna Carta. You've probably all heard of Magna Carta. The Bill of Civil Rights basically is what it was. And what happens when citizens are given a body of rights and a body of laws to govern their everyday lives? What does that mean? Would anybody like to tell me what that requires? In the 13th century, the king said, okay, I'm not just going to make laws day by day. We're going to have a written set of laws here. Principles. They weren't really laws. They were more basic governing principles. What does that require? People are given rights. The first time in our part of the world, not the first time in history, but the first time in our part of the world, people are given rights. What does that require? Anybody? Any suggestions? No? It requires somebody to administer those rights. Not just the king, but it requires somebody independent of the king. And the king was too busy doing kingly things, whatever kings did in those days, fighting wars, or maybe just sitting there looking cool with his crown on his head, whatever. The king was too busy doing his duties, so they needed specialists who were trained in legal thinking, people who were scholars, people who were educated. Remember, back in those days, even kings were often illiterate. Kings couldn't read or write. Very often, I'm not saying they were all illiterate, but many of them were, as were the majority of the population. But to administer and interpret and apply these laws, you needed people with an education. And those people were usually scholars who were trained in Latin. Now, you had many different languages in Britain until the Normans arrived, and the Normans brought with them their language, which was a sort of a combination of French and Latin. It was early French. It was more Latin than French. And Magna Carta was written in Latin. So you needed people who spoke Latin, and you needed people who were scholars and who were trained how to, let's say, solve disputes between people. The world could probably do with a few of those at the moment, people trained in solving disputes and sorting out wars. But the royal courts in England developed. So Scotland was still not quite part of the whole system at that point. So you had the royal courts of England. And over time, the courts didn't just rely on Magna Carta. Magna Carta, remember, was pretty general. So when the courts made decisions, they had to, in the interests of fairness, they had to apply uniformity. They had to have consistency. So What do we do to ensure consistency? They had scribes in the courts who would record decisions that were made, and then subsequent cases with similar facts. So the same circumstances, A has a problem with B over a fence in his garden. A is making lots of noise. B sues him because it's affecting his right to enjoy his garden or whatever. So we can't have one decision going one way and the other decision in a similar level of court going the other way. So what happened was the courts started to record their decisions and to apply them further on using the principle of judicial precedent. As we see here, we have a judgment, Smith versus Jones, and Smith versus Jones, that's just generic. Again, thank you, ChatGPT. But Smith versus Jones, as a case, Smith sues Jones. In future, we might have Mr. Brown versus Mr. Green, but it'll be the same circumstances, and the previous reasoning, the legal reasoning of Smith versus Jones from years or decades before will be used. So, and they use this in the US. So in that sense, the US is very much a common law system. So just to review the main differences so far. Roman law, we have a written constitution. Argentina has a written constitution. All countries, I believe, in South America and Central America and the US, all American countries have written constitutions. All European countries, as far as I know, have written constitutions, except the UK. The UK does not have a written constitution. Britain does not have a written constitution. They have what's called an unwritten constitution. So all the organs of state, they are just carried on by tradition. The king addresses the parliament on the opening of parliament every autumn, I think it is, and so on. It is written, all the rules are written, but there is no formal book that we can say is a constitution. So the constitution is at the top of that pyramid. Then we have various codes, or we also call them statutes or legislation in common law countries. So you have all those codes, and they are the source of law. For example, commercial criminal code, maybe personal injuries, environment, insurance. You'd have regulations covering all those areas of life, and they're all written down, they're all codified. In the common law, we have constitutions. The constitutions can vary. In Ireland, our constitution is around 120, 130 pages. In the US, their constitution is around 3 or 4 pages. They do have a lot of amendments on top of that, but their basic constitution is just a few pages. In Ireland, we have an extremely long written constitution. Why? Because we're Irish, we talk a lot, and even when it comes to laws, we've got to get a lot of words in there. So that's why we have such a long written constitution. Judicial decisions, like I mentioned, the concept of stare decisis, as we pronounce it, you might pronounce it differently. We call it stare decisis. And its principles based on binding decision. And of course, we do have statutes as well. And the amount of statutes is growing even in the common law system. Eventually, like we said earlier, the two systems will meet. Now, the doctrine of stare decisis, it comes from Latin and it means to stand by things decided. Basically, we adhere to legal precedent. And if you watch Suits or any of those American TV series about lawyers, any John Grisham novel made into a movie, they're always talking about precedent. Everything is about precedent. Okay, guys, do we have a precedent on this? Everything in the US in the courts is about precedent, and in ours as well. And where is precedent binding? Precedent from a given level is binding on courts of a lower level, where a case of similar material facts come into it. If the material facts are different, it's a whole new case. But if a case of similar material facts comes into a lower court, the previous decision, the precedent from the higher court, is binding. If it's a court of the same level, so you have a high court case, and then 20 years later, a similar case comes into the high court again, it's not binding in courts of the same level, but it is highly persuasive. If there is no need to make a different decision, then they won't. And the legal reasoning that they use is called the ratio decidendi. So it means it's basically the basis of reasoning. So judge looks at the facts and says, okay, this reminds me of Smith versus Jones 25 years ago. Actually, it's the very same case, very same circumstances, just same stuff, different people, same idea. Okay, let's apply the rule of Smith versus Jones. And later we'll take a look at some examples. Case law does have a role in some Roman law countries, like here in Romania. Sometimes in court, they do actually cite precedents here in Romania, but they are purely persuasive, that's all. Just to help the judge, a lawyer might say, Smith versus Jones, that's an important case in Britain or in the US or in Germany or whatever, or here in Romania. The reasoning there seems to have been pretty good. Why don't we use the same reasoning in this case? But it is purely persuasive. So now we're going to look at two cases. Has anybody heard of the first one? Is one of the most famous in British law. I don't know if anyone has heard of this one, Donoghue and Stevenson. It's a Scottish case, and it's from a century ago now. A woman went to a cafe with her friend one evening, and she ordered a ginger beer. Now, she wasn't paying. Her friend was paying. So the woman got the ginger beer. The contract, it would already have fallen under contract law, but in this case, contract law was rejected by the lower courts because they said she didn't have the contract. She was not paying. Her friend had paid. So the contract was between the cafe and by association, the manufacturer and the friend, not between Mrs. Donoghue. So it went through the various courts, and eventually it got to the House of Lords. By the way, when you see this kind of legal citation, 1932, obviously the year of the case, of the final hearing, Appeal Court, AC, and HL is House of Lords, which is the Supreme Court of Britain. The British Supreme Court is part of the House of Lords. Not all members of the House of Lords are qualified to sit on the Supreme Court, only those who are qualified as judges. So it's a branch of the House of Lords, the British Supreme Court, but we still call it the House of Lords. And we call the judges on that court the Law Lords. Sounds very grand. He's a Sir Jonathan Humphreys Dimbleby. He's a Law Lord. Sounds very grand. So it went it went on appeal to the House of Lords, and the judge in that case said, okay, so there isn't a contract between Mrs. Donoghue and Mr. Stevenson, who was the owner of the company that had manufactured the ginger beer. So there was no contract that she could sue under, but the judge said, but she can still sue. Why not? Because after all, Mr. Stevenson, as the manufacturer of the ginger beer, should have ensured that there was no snail, decomposed or not, that there was no snail in the product. I mean, imagine today you go to a bar, you buy a bottle of beer, you open the beer and there's a dead mouse or a snail or something. Imagine how you would react. It would be pretty traumatic. Maybe she overreacted. She was not treated for psychological trauma or anything, Mrs. Donoghue. She simply sued on the basis that she said she felt traumatized and it upset her. She didn't get very much money. She got very little. This case is not famous for big payouts. It's famous for the principle. And the principle is that when you manufacture something, you have a certain duty to the people who will use it, not just people who will legally pay for it, but the people who will use it, who will eat it, drink it, play with it, use it to cook in their kitchen, use it in their garden, whatever. That the manufacturer has an obligation, or what we call a duty of care, to anybody who might use that product. And this idea of a duty of care became the foundation of modern negligence law. And in common law systems, all personal injuries cases are, well, maybe some exceptions based on product liability under contract law, but in most cases, the neighbour principle is used. And what is the neighbour principle? The same judge, Lord Atkin, in that case, he said, okay, everyone has a duty of care to their neighbour. Now, who is your neighbour? Your neighbour is the people that you come into contact with. Anybody you come into contact with, not just the person who lives in the next apartment to you. Your neighbour is anyone who is near you at the moment that you happen to be in a particular place. So if you are at the beach, nice sunny warm afternoon, you are at the beach. If you, let's say, kick sand into somebody's face, you're messing around, you're kicking sand or throwing sand, you throw sand into somebody's face, something gets in their eye, causes eye problems, and eventually they lose the sight of that eye. Are you responsible under the neighbour principle, under the duty of care idea? Yes, you are still responsible. So we're not here today to look at the finer points of Donoghue and Stevenson or the neighbour principle or the concept of duty of care. We're here to look at what the case established and how it established it. So this case is a classic example. It's one of the most often cited cases. It's a very famous case of where new laws were made that have applied down through a century of history. The neighbour principle and the concept of the duty of care are applied in so many civil cases today, not just for personal injuries, but for loss or damage to property as well. Now, I want you to think about something and maybe answer this question. How would this case be decided under Roman law? Let's say in Argentina, how would this case be decided in Argentina? Pause for some water.
Perhaps the usual way is to observe the codes, and if this is considered among the points in the code. If not, I don't know.
Yeah. Yeah, if it's not in the code, if it's not there in the civil code created by the country's legislature, a parliament, in other words, in a parliamentary or government assembly in most democracies. So yeah, so your parliament makes the law, and then it's legal code, it's a statute, and therefore it can be applied in court, interpreted and applied to the case, the facts of the case. And either they fit the code, the facts, or they don't. And if they don't fit the code, then no case. So who would you say has more power to make law? Judges in Argentina or judges in Britain? Who has more lawmaking power?
In Britain, of course.
Yeah, absolutely.
Yeah.
Maybe not in the
Yes,
lower
I feel-
cases,
Yes, I
but
feel the same.
in the higher cases, for sure. In the higher cases, the judges have been instrumental in making laws. Now, let's look at another case then. Carlyle and Carbolic Smoke Ball Company. This is related to contract law. Now, a company advertised, and we see this in advertising all the time, buy our wonder product and your world will magically transform. You will live in utopia forevermore if you buy our product, whatever that product is. It might be some medical product that cures all ailments. It might be a garden tool, and you go out in the garden and you use this tool, the solve all tool, and you'll have a magic garden there. The Garden of Eden will suddenly be there outside on your little on your balcony, in your backyard, whatever. The Garden of Eden will be there. Just buy our product. In this case, and this is in 1893. Now, £100 reward. £100 in 1893. So 130 years ago. How much would you say that is today? Anybody like to hazard a guess?
No idea.
It's around, yeah, it's something like 100 times. So it's around £10,000 today, which would be maybe 13,000 US dollars. Now, all the companies out there, every manufacturer in the world, every salesperson, they all tell us our product is wonderful, but they don't, to use an expression that we have, they don't put their money where their mouth is. They make all the promises, but they're not going to be so bold as to promise you a reward if the product that you buy from them doesn't quite produce the goods. But these guys, they said, £100 reward. So in modern terms, let's say 13,000 US dollars reward if you use our product and still get sick. So what was the product? What did they promise the product would do? They made this little, mothballs that you might put in your cupboard or a drawer in your home to keep moths away from your clothes. This was a bit like that, this smoke ball, the carbolic smoke ball. And in the 19th century, of course, we didn't have much in the line of consumer law. So what was happening was they were saying, manufacturers were saying, this product is wonderful. And this company said, if you get sick again after using this product in your home, we'll give you a huge pile of money. A woman used it, still got sick, and relying on their promise, claimed the money. Now, the court looked at a few questions. Was this an offer, or was it just advertising talk? Was there acceptance of the contract? The offer was, if you buy this, we will give you money if you get sick. Prove to us that you get sick, get a doctor's certificate or whatever, and we'll give you the money. Was that seen as a serious offer? And if it was a serious offer, was there acceptance? And was there something very important in common law, an intention to create legal relations? Now, what does that expression mean? Anybody like to volunteer an answer? Intention to create legal relations, or intention to enter into legal relations. It means, do you intend your side of the bargain to be a serious contract? It must work both ways. So somebody offers you, let's say you go to buy a second-hand car, and some guy says, okay, this is a great car, I will sell it to you for $10,000. Now, for $10,000, it's a second-hand car, but it's a few years old, but we expect it to work and to get us from A to B and to do what a car does. So when you buy that car, do you intend the contract to be a real contract? In other words, are you taking the contract seriously?
Implicitly, yes, and accepting the terms, and I,
Absolutely.
of course, of that I buy or I acquire the product.
You expect the seller to be serious and to give you a serious car, but likewise, if you drive away today in the car and you tell him, I'll be back tomorrow with the money, and he lets you drive away, he trusts you, and then you don't come back tomorrow with the money, you are also liable to pay him. He can take you to court because, well, you have, by accepting the car, you are expressing an intention to enter into legal relations. So if it goes one way to benefit you, it must go the other way as well. You must be serious about your obligations to the other side too. So that's what that concept is. And the court, after asking all these questions, was it a serious offer? Yes. That's how Ms. Carlyle saw it. Was there acceptance? Yes, she accepted the offer. Was there intention to enter legal relations? Yep, she took it seriously. So therefore, there was a binding unilateral contract. So the Carbolic Smoke Ball Company, guess what? They were held liable. Now, in a Roman law system, would the judge have gone through this analysis or not? How would a judge in Argentina have seen this case? Like Donoghue and Stevenson, what would the Argentinian judge do? Very simple.
I presume he will analyze what a contract means for our laws, and if this is codified or not, and then go for the resolution, but not just asking question and answering himself if this is right, this is okay or not.
Yeah, exactly. He would go to the codified law. He would look at the relevant statute, commercial code number 45679 of whatever year. He would check the relevant provisions there. If somebody sells something and they make a promise, then they are legally bound to deliver on that promise to the consumer. We actually, since Carbolic Smoke Ball Company, in the 1960s and 70s, we had a lot of consumer legislation. So nowadays, it's not just a case. We have codified statutes on this as well, like the Sale of Goods, Supply and Services Acts. There are many of them, different years, and each builds upon the other. So we can see here that the judge relied on his own reasoning, on principles. He did look at previous cases as well before he came to his conclusion. He didn't look at statutes, mainly because there was no statute at the time to look at. Now, what about court procedure? Does anybody have any questions, any comments so far? So we've looked at the history of both systems, and we've looked at the doctrine of stare decisis, a judge-made law precedent. Has anyone got any questions? Any terms that I've used that you don't understand? Any comments? Anything you'd like to say? Any observations you'd like to make?
Personally, I'm fine.
Okay.
No, very clear. Thank you.
Okay.
Yes, it's
Okay,
been
good.
quite clear, like.
Okay. So now let's look then at court procedure. And again, this presentation is just designed to touch on certain areas. And court procedure, we're going to look at a few things, just skimming the surface. And one of them is the nature of trials. In civil law, not in all civil or Roman law systems do you have an inquisitorial setup in the courts, but in some, like in France. In Romania, it's more adversarial, in Romania and in Germany. But in France, it's very inquisitorial. And in an inquisitorial system, I'll read this out to you, the judge investigates facts and has more of an inquisitorial stroke investigative role. So the judge pretty much does what the prosecutor does. He often questions the accused person, the claimants, if it's the person taking a case in a civil action, so under civil law, in our understanding of civil law, or the defendant, or the witness. So the judge will ask all the parties in a court case many, many questions. And like I said, in France, his job is specifically to ask those questions. And I think in some French courts, I'm not sure, but I think that in some French courts, the judge is the prosecutor. In common law systems, we never get that. Our system is purely adversarial. In other words, it's a bit like a football match. You have team A, team B. So we have the claimant and the defendant in a civil case. In a criminal case, we have the prosecution and the accused or the defendant. And the judge's role is to sit there as an arbitrator. In other words, as a referee. The judge's role is strictly neutral. In the common law system, judges are strictly neutral. They listen to both sides and they only make their decision at the end, or if it's a criminal case and there's a jury involved, they will give instructions to the jury, but that's it. And if it's a civil case, they will just make up their decision based on the evidence from both sides. But like a referee in a football match, the judge absolutely and very strictly does not show favoritism, or he's not supposed to anyway, show favoritism towards either side. So each side goes through the motions. They introduce their case, they'll present their arguments, they will call their witnesses, and then the other side will cross-examine witnesses, and then the other side will go and present its witnesses, who will also be subject to cross-examination. And all this time, the judge is just sitting there. Now, there are exceptions where the judge will ask people
Perdón, ¿se habrá trabado la...?
Ay, estaba por preguntar lo mismo. Me parece que se trabó.
No sé si se habrá trabado la clase de ellos o la nuestra, o se
No, la
pausó.
de la nuestra me parece que se
Está
trabó.
pausada, me parece, ¿no?
Me parece que sí.
Sí, está pausada.
Ay, me parece que se fue.
Pensé que era mi internet.
Sí, yo estaba por preguntar en el grupo. A ver, le voy a escribir a Nati en el grupo por las dudas.
Hola chicas, les pido disculpas, tuve un problema yo con la compu. Ahí les sigo pasando la clase, les pido disculpas por la interrupción, ¿sí?
Bueno, perfecto,
perfecto.
gracias.
Discúlpenme. Perdón, la retrocedí solo unos segundos como para enganchar bien el tema, pero ahí ya sigo con la clase, les pido disculpas.
Sí, no pasa nada. Nos habíamos quedado en la parte de court procedures.
Exactamente, sí. Ya lo estoy poniendo, chicas, disculpen.
Gracias.
A ustedes.
To later. Which one do you mean? That kind of a question. Or would you like to tell us what time approximately you witnessed this? The judge will ask clarification questions, but only to clarify. That's all, not to get specific information. That's up to each side. Now, the role of judges. So we've already seen in Roman law, judges go for a more literal interpretation based on the wording of statutes. That's all. They just look at the statute. That's it. Common law judges look at and things like the concept of reasonableness. This is a big concept, a big word in common law systems. What is reasonable? So the judge has a lot more discretion. In one sense, it's good because the judge can be more rational and more, let's say, maybe fairer on the day. But the problem with that is the judge is also one human being. Whereas when statutes are enacted, they're done in a parliament after much debate, much discussion. So we could say that in most cases, statutes are well thought out. Whereas the judge just coming up with an idea because it's reasonable, maybe it's not reasonable. We hope it is, but well, I'm not saying one system is better than the other. I think both systems have their advantages and disadvantages. Now, what about the spirit of the law as opposed to the letter of the law? Let me give you an example. You have a provision. It wasn't actually a statute as such, it was more of a deed from the late 19th century. And it gave people a certain right, a right of access. And it said, people on foot shall have a right of access, blah, blah, blah. And then it said, drivers or owners of horse-drawn vehicles shall not be allowed to enter this field. Drivers of horse-drawn vehicles shall not be allowed to enter the field. The case comes from, I've forgotten the name of the case, it's just that the fact stuck in my head. And it's from around the 1860s, 1870s in Britain, in England. Now, how would you guys interpret that if it goes into court and you have to interpret that? Would you say that A, according to the letter of the law, if this particular deed says horse-drawn carriages shall be prohibited, what about a guy in a car? A modern car, it's not horse-drawn, of course, it's a modern car. Is he prohibited from entering that field as well? Or is he allowed because he doesn't have a horse-drawn carriage? How would you guys see that? I'm curious. It's an interesting one, isn't it? How would the letter of the law be interpreted there? If we use the letter of the law that says horse-drawn carriages shall be prohibited, but there's no mention of cars. So cars, bring your Range Rover in there, no problem, or a big tractor or a big articulated lorry. The law does not prohibit, the deed, which is the law in this case, does not prohibit them. So that's the letter of the law. Now, if we use the spirit of the law as a guide, what does the spirit of the law mean? What does the concept mean? The spirit of the law. Anybody like to comment? No?
The spirit of the law, it's like being right and, how do you say, equal for the parts. But for this, you need a lot of, I don't know, knowledge and reading, and it's the decision you're taking as a judge is on you, and this person may be harmed because of your decision. So it's like you're trying to be as equal as possible because of the spirit of the law.
Yeah, you're pretty close there. The spirit of the law basically is, what was the intention? Now, we don't know for sure, so we have to guess a bit here. What was the intention of the guy who wrote the deed back in the 1860s, 1870s, when he said horse-drawn carriages shall be prohibited? Did he mean it was only horse-drawn carriages, and that if you have a big Range Rover, you can drive through the field? Is that what he meant? Probably not. Why? In the 1870s, there were no mechanical vehicles. The only vehicles back then were probably wheelbarrows, bicycles, and horse-drawn carriages. So the guy who wrote into the law back then, into the deed, saying no horse-drawn carriages, what did he probably mean? Who could cross the field? Who could have access? What about pedestrians? Were they okay? They probably would have been. What about someone on a mountain bike? Well, there were no mountain bikes then either, but on a bicycle, such as they were back then. What about somebody on a bicycle? He probably thought bicycles are no problem. Sure, your own risk, you might fall off a bike in a muddy field or a rocky field, but hey, your risk. And a wheelbarrow, well, you'd need a wheelbarrow in a field probably anyway. But horse-drawn vehicles, no, because they would probably do damage to the ground or whatever, or injure people who might have been using the field for recreational purposes. So, which they actually were. So, horse-drawn carriage. So, in a Roman law system, the judge would probably say, because he has to work with codified law, he would say, well, this particular rule is, it says that no horse-drawn carriages, but it doesn't say anything about cars. So cars can go. Yep, they can go. Whereas a common law would probably say, well, there were no cars in 1870, but if there were, they were probably intended to be excluded as well. See the difference? And if we go through the law, we'll find loads of cases like that. So notaries and lawyers. In Roman law, notaries play an important role. Let me ask you guys a question. If I buy a property, let's say I decide to buy a house in Buenos Aires, who would handle the legal conveyancing? Would the lawyers handle it, or would the notary handle it? Who would handle the legalities?
The notary.
A notary, yeah. And who would the notary represent? Let's say you're selling me a house somewhere in Argentina, let's say in Buenos Aires, you're selling me a house. Does the notary act for you or for me? Or who does he act for?
I'm not sure about your question.
Can you, I think my wife is locked out. Can you give me 1 second, please? Just 1 second.
Okay.
Sorry about this. Yeah, sorry about this. Oh, you're in. Yeah. I'm still doing it. Okay. Yeah, sorry about that. She managed to get in. Okay, my apologies for that. So, who does the notary act for? Does the notary represent the purchaser, me, or does he represent the vendor and the seller, you? Who does he represent? Does he represent both or none of us?
As long as I know, Nati will correct me if I'm wrong, each party has its own notary. I mean, he cannot represent both parties at the same time.
Yeah, mainly it has to do with legal certainty. So it's sometimes they usually act on behalf of what's written in the statutes, what our laws stipulate, you know, like the state.
Okay. So how would it work in Argentina? Excuse me, if I was buying a property there, how would it work?
It would be advisable that you contact a notary public so that they.
Okay.
This is not the only way, right? This is the best way to do it.
Okay.
Of course, people can enter into private contracts, which then they will have to prove whether these are binding or not, you know, because that will depend. But like according to solemnities and formalities, the best way will go like you go to a notary public in order to have all the documents, like the official documents from the property office, you know, in order for this sale to have like publicity so that everybody knows you are the owner.
Yeah.
Because notaries public here, they are lawyers who study, first they graduate as lawyers, then they study 2 more years about real property.
Okay.
And
Okay.
after they study real property, they become a notary public. However, sometimes they do not have a seat in registries, because there are certain registries within the city which are like a fixed set of registries. So you have to wait until a new registry is open, or one of those existing registries has no other notary. So in that case, you will start holding like a title to that registry, right? Something like that. This is how it works here. So that's why I say that notaries public here, they represent what the law states. And in particular, what they represent is legal certainty regarding title, the transfer of property, possession, and all of that.
So quite similar to Romania, there will be just one notary involved, but that notary doesn't have a loyalty to either party. He has a loyalty to the law to ensure that righteousness and fairness and justice are exercised. So if there is something wrong with the property, he will say to the vendor, he'll say, what about this? There's a problem here with the legal title. You need to get this sorted out. But he will also ensure that any obligations that the purchaser has to the seller, he will also ensure that they're applied as well. So they're enforced as well. So the notary is like, again, he's he's like the judge in the adversary. He's like the adversarial system judge in common law. His job is to act as an arbitrator between the parties. Yeah, his loyalty is to the law. Whereas, and you all know what I won't go into it here, what the lawyers do in your system, but in the common law then, drafting and overseeing the execution of important documents is done by the solicitors or the lawyers for each side. So let's say you're buying a property in Ireland or England. You would go to a solicitor, you would hire a solicitor, you would not actually go to a notary. Notaries do exist, they have a very minor role. Many solicitors are also notaries. You do not require an additional qualification. You train as a solicitor or a barrister. If you are a solicitor, then you will handle a lot of conveyancing, in other words, real estate transactions. We'll come back to that in a few minutes. So the notary's role is very minor. A notary is usually also a solicitor, and it's just a little, an extra earner. That's all. You might pay 30, 40, 50 euro to go to the notary to have an important document stamped as authentic. That's all. And that's all notaries do in our system. They attest the authenticity of documents. That's it. What about juries? Do you have juries in Argentina? Yeah? No?
At present, we are having this type of like oral proceedings, just when sometimes with juries, but this is like being just now implemented, you know, just in the criminal area. And there are some states, some provinces, I mean, that with around 14 out of 23, which have already adhered to this system, but this is like brand new for us, to us.
In France, in some courts, they use juries, but in Germany, they don't have juries. In Romania, which I know better, they don't. In higher court criminal cases, personally, I'm not a big favor. I'm not a big fan of juries. I think part of the past, because I think the law now today is too complicated for non-qualified people to make decisions, but that's just my own opinion. Juries in our system, juries are usually 12 people. In some cases, they have smaller juries, maybe 10 people. And it may be a unanimous verdict that is required, or a large majority. The tendency is for unanimous verdict in criminal cases, or a large majority, maybe 10 out of 12. It depends on the system and on the court, but for civil cases, it's usually just majority jury decision. For civil case, like personal injury or contract cases, for example, commercial cases. Juries do not theoretically decide on the facts, on legal matters. They're not qualified. They don't decide on legal matters. They decide only on facts. World facts and legal issues are becoming more intertwined. Based on the idea that 12 or 10 people can give a more reasonable decision person. Just an hour, so we need to get through this. So comparative transactions. I will race through these because time is becoming an issue. So a notary in Romania, I'm only using two examples, using Romania as an example of a Roman law system. Going back to the house purchase, you sign a preliminary agreement, or the antecontract here in Romania, is usually signed first with the notary, in front of the notary in his office. The two parties do the pre-contract or the antecontract, and there is a deposit paid between, agreed between the parties, might be 10%, might be 1%. Parties to agree. The notary checks out all the documents, all the title documents, make sure that everything is in order. It might take him a couple of weeks to do this and to prepare the required documents for the completion of the sale, and there are very few documents required. So after maybe 2 or 3 weeks after you sign the antecontract, then you go back to the notary again, you pay the balance of the money, you sign the forms, and the property is yours. We have a land registry in the Carta Funciară in Romania. You probably have something similar in Argentina. Now, in Ireland, again, a system that I know better than UK, as common law, of course, it's lawyer-centered. So two parties agree to buy / sell a property. Each party instructs their solicitor. The solicitors will then contact each other. They will draw up the contract of sale. A flat deposit, a standard deposit of 10% is paid. And then once that's done, the purchaser solicitor will send a lengthy document, the requisitions on title, with lots of questions which the vendor solicitor has to answer or cross out as not applicable if they're not applicable. The requisitions on title, how long would you reckon it is? This is a legal document that happens in all property transaction cases. Would you say it's 20 pages, 30 pages?
Mike, can I ask you a question? Do you call it like contract of sale, or do you eventually call it like a deed?
Yes, very, very good question. Okay. And when I first came to Romania, this used to confuse me. We call the contract, the first document in Ireland, in any common law system, the contract of sale, it's an agreement to buy / sell a property, but it is not the transfer. The transfer is done at final closing, and the land registry don't care about the contract. The land registry, to transfer the ownership on the register, the land registry wants to see the actual deed of transfer. That's what they want to see. In Romania, you have the antecontract. The pre-contract is what you sign at the beginning. And when you sign the contract of sale, that transfers the property. So what Romanians call the contract of sale is effectively what we would call the deed of transfer. But in Romania, the contract of sale would be longer. It might have 5 or 6 or 10 pages. In our system, the deed of transfer is like 4 lines. That's all. I, Mr. X, hereby of such and such an address, hereby agree to transfer in its entirety the property described in Schedule 1 attached here to for the sum of €250,000, whatever. That's it. Very short, but the contract of sale at the beginning is huge. It's like 20 pages. The requisitions on title. The requisitions on title is around 300 pages. But you can cross out a lot of them because you have a big, for example, on apartments. So if you're buying a house on its own grounds, then you can cross out the bit relating specifically to apartments. If you're buying agricultural land, you can cross out apartments and houses, and so on. So if you're buying an apartment, you can cross out the whole area on agricultural land or commercial premises if it's just an owner-occupier residential apartment, in other words. So you can cross out a lot of it. So you would end up probably to about 1 to a half. Still a lot of pages. It's still 100 pages or so or more.
You will have to read
that a solicitor,
quite a lot.
yeah, that solicitor for the vendor has to answer, because the solicitor, because a very important principle here is each solicitor is responsible to his own client. And it is caveat emptor. You know, that Latin term, caveat emptor, very much applies in our system. Buyer beware. So if the solicitor for the purchaser misses something, he makes a mistake, he doesn't carry out what Americans refer to as due diligence. If he doesn't carry out due diligence, it's not the vendor's fault, it's the purchaser's fault. It's like if you're selling a car, if the owner of the car says, this car is perfect, that's one thing. But if the owner of the car says, look, I'll sell you this car, but it's not a great car. There are some issues with it. You need to get your mechanic to have a look at it. I'm not responsible, but I'm selling it as is. Now, you come along and you get your mechanic to look at my car, and your mechanic looks at the car I'm selling and says, that car is perfect. And the next day it breaks down and it costs $1,000 to fix. Who's liable? Am I liable, or is your mechanic liable? Caveat emptor. That is how real estate transactions operate in the common law system. So, and the whole thing, because of the whole requisitions on title, takes so much time to check out and to answer. Instead of 2 or 3 weeks, a typical transaction takes about 6 to 8 weeks from the time you sign the contract, or Romanians call the pre-contract, short document, to the time they sign the long contract. It's 2 to 3 weeks. What we call the contract, from then to the deed of transfer, takes about 8 weeks. Maybe more. It could take months if a problem arises. If something arises, cases have been known to take years to finish, but normally we're talking 6 to 8 weeks. So, okay, now let's look then at contracts. Civil law, Roman law contracts based on general principles contained within the code. So contracts can be pretty simple. Yep. Heavy reliance on statutes and regulations, and on the civil code provisions and default rules. So even if something is missed out, there is a default codified rule in. Let's take a quick look at this. This is a Roman law contract. What do we notice compared to this contract? Now, compare this contract, the Roman or civil law contract. The language, how would you consider the language in this? The language in this contract, would you say it's complicated? Is it straightforward?
For me, it's straightforward. I mean, it's clear and
yeah, it is
not that complicated.
Yeah. Personally, I love Roman law contracts because they are clear and there are clear principles. Yeah, there's the default laws to go back to if something goes wrong. Payment shall be made within 14 days from the date of the invoice, delivery within 30 days, blah, blah, blah. Now, in the event of delay, pay close attention here, please, to number 4. In the event of delay, the seller shall be liable for damages in accordance with the applicable provisions of the Civil Code. So, in other words, what the law says will apply here. So, if by damages, we mean probably in your system too, we talk about damages, we mean compensation. So, the seller shall be liable to compensate the purchaser if there is a delay in accordance with the law. And then, just to make sure, the contract shall be governed by the relevant provisions of the, let's say, Argentinian. You notice everything is more detailed here. Not so clear. It's about detail, not clarity and simplicity. knows about detail. Why do we go into so much detail? Think about where law comes from, traditionally common law systems. Think about the whole concept of reasonableness. Is there codified law? Not so much. There is less of a default. It's growing, but there is still less of a default than in codified systems. So we have to be more specific. The seller shall deliver the goods to the buyer's premises within 30 days of the date of this agreement. Example, but you would say something like premises as described in detail in Annex 1 attached hereto. Everything is described in annexes and schedules, and everything is about the detail. And number 4, in the event the seller fails to deliver the goods within the specified period, the seller shall be liable for any loss and damage suffered by the buyer as a result of such delay. Compare that to number 4 here, much simpler. Here, in the common law one, it's much more specific. And number 5, the agreement constitutes the entire agreement. Oh, sorry, this agreement, maybe I should have used the word contract, constitutes, to avoid repetition, constitutes the entire agreement between the parties and supersedes all prior agreements, representations, and understandings. In a Roman law contract, there's no need to go into all this because it's all there in statutes. There's the default law. Here, fewer statutes, we have to be specific. Between the parties. We know it's between the parties. Logic tells us it's between the parties, but a lot of our legal documents are not so logical, or they don't appear logical to the average person, but to lawyers, it's like we have to be specific. Seems crazy, but we have to be specific. That's why we use language like the first part of the first party in conjunction with the second part of the first party hereby agrees to sell to both parts of the second party. Oh man, it's mind-boggling stuff. Or all that and those, the property situate in the address at the location described in the schedule, and there might be a whole page in the schedule describing the location of the property, plus a map. In a will, shall give, bequeath, and devise his property. Now, give, bequeath, and devise are all 3 words for leave his property when he dies. When Mr. Johnson Sr. dies, he leaves, according to this will, he lives, devises, he gives, devises, and bequeaths. Why do we use 3 verbs? Because each has a tiny little difference going back 100 years or 200 years into the history of common law. Each word will have a slightly different meaning, and that's why we have to state it. All prior agreements, representations, and understandings. That's why our contracts are so different and so much harder for people to understand. Can they not be written in modern English? Whereas civil law contracts are. Back in my early days as a law student, I remember dealing with contracts like this, and I thought contracts everywhere in the world were written like this. And then one day I was an apprentice at the time, and I saw a contract from a law firm in Switzerland, and it blew my mind. Why? Because it was written in English, plain, simple English. And it said in 2 pages, maybe 3, what a common law contract in Ireland would have taken 8 to 10 pages to say. So it was much simpler and much clearer, and I thought, why can't it be done like this everywhere. Why can we? And I remember saying to the boss in the office, why can we not do that? And he explained why. And his explanation didn't make sense in normal English, but in the crazy world of common law system, it made total sense, if that makes sense. So that's contracts. Now, any questions about contracts? Today, we've only touched on contracts. In a course on contracts, on contract writing, we would deal with a lot of actual examples, not just generic examples. We would deal with a lot of real life examples and the specific languages used, because that's very important. But we would do that in an actual contract writing course, which I do if anybody is interested in learning more about contract writing for, let's say, American clients, or contracts that might be dealt with in a common law country for some reason, US, Britain, Australia, whatever. I offer contract courses, but also I can offer some consulting, short-term consulting. Contract tendency to use precedent. Why? Anybody like to answer that question? Why? Why would there be a growing tendency to use precedent? I mentioned earlier that in Romania, for example, they are using precedent not as a binding doctrine, but they're using it more to influence judges' decisions. Why? What's the advantage of? Yeah.
Yes, we usually use it in order to try and somehow like influence what the judges might decide, but of course it doesn't influence them too much.
Yeah, we try to influence them maybe with common sense. Yeah. It may not always work, and we cannot make it work. We cannot say, but the judge, we cannot base an appeal on that. We cannot go to a higher court and say, well, the judge didn't follow the principles of Donoghue and Stevenson. We cannot do that because it's not binding. But what we can do is hope that by using a logical, reasonable, fair precedent, we hope that we can influence the judge. So it can be used as an argument, it's just not binding. On the other hand, in common law systems, we use statutes more and more. Why do we use statutes? Anybody like to? We have a few minutes. Anybody like to comment on why we use statutes more and more today?
I have to assume that to have some reliable precedent and to give some, I don't know, the rules person to be sure that this is as fair as possible within the modern world. Well, I mean, like to provide a sure frame. I suppose I'm just.
You're right.
Resuming and thinking about.
No, you used an interesting turn of phrase there. You said a sure thing, certainty. And codified law gives us certainty. If we go into court in the old style common law courts, if we went in court using precedent, it's up to us to use, to the lawyer going in, to use precedent. But maybe he's not so good at research, and maybe the other side will come up with the better precedent to counteract that. And maybe the judge will decide not to use it. The judge will say, well, I'm not sure. I think the material facts are different in this case. Or, oh, that was in a court of on the same level, but it's persuasive, but it's not binding. I don't have to follow it. There's less certainty with precedent. And besides, things are so complicated today. And there are so many cases, all cases get heard in the US, the UK, India with 1.5 billion people, Indian courts, Pakistani courts with another 180 million, I think, Britain 70 million, America 320 million. Imagine all those people in the world, and there are hundreds, thousands, tens of thousands of cases every day being heard within the common law family of the world. Can we keep track of precedent? No, can't. And besides, it's easier nowadays to actually pass laws and have that certainty there. So what kind of areas then would we have an overlap? What kind of areas? There's some environmental protection is a big thing. And now in Ireland, there's a huge body of law about environmental protection. Oh yeah, and in case anybody is wondering which takes precedence as opposed to precedent, same spelling. This is why the law is so confusing to people. Precedent, why would the law, which system, yeah, sorry, I'll start again. Which system or which source of law takes precedence over the other? Which would you say is more important, in other words? Would you say statute law or case law? In Britain and Ireland, for example, which would you say is more important? Which will the judge ultimately refer to? Would you say?
Hopefully the statutes.
Yeah. Statutes override, the statutes will always override any former judicial decisions. That's the whole idea of statutes. The idea is that in changing times, we need to change laws. We cannot stay stuck in the same laws forever. Funnily enough, not many laws have been passed to overturn old cases like Donoghue and Stevenson, the one we looked at earlier with the snail in the bottle of ginger beer. Very few statutes overturn the principles of that case. Maybe they don't need to. It's actually good principles, I think. The duty of care that we owe to everybody. And if you manufacture a product, you owe a duty of care to users of that product, not just customers under contract law, but users under an area today of what we call product liability. So we have such a complex world, so many commercial transactions. You know, you go into a shop, a supermarket, you slip on a wet floor. Do you have a case for personal injuries? Yes. But there may be exceptions, and they need to be codified in law. So the two systems don't necessarily cancel out each other. A legal principle under stare decisis, a legal precedent there can still apply within a codified system, unless that codified system overturns it. But yes, statutes can overturn precedent and do. Yeah, they do. And that's the whole idea. Precedent, the precedent may be outdated. What about other areas? Revenue and taxation. Again, it's a very modern area. Company law is changing all the time. We need specific regulations. Precedent cannot determine what, let's say, the different codes for the articles of association in a company. When you set up a company, in your articles, you have the company objectives. Each system will make up its own categories of business, into at least one of which your company must fall in order to legally do business. Precedent cannot establish that. We need statutes for that. Again, consumer law. IT, a big law in Europe in the last few years is GDPR. General data protection and regulation law, all about IT, all about what you can do with other people's information, mergers and acquisitions, M&As, and cyber protection. There are lots of people out there. We all come across all the internet scammers every day. No 17th century or even 20th century, 1980s principle is going to protect us against internet scammers, phishing, for example, 419 letters. We need modern, up-to-date legislation to deal with those. And I think that is why the two systems are becoming more and more, also in procedures. I think that juries are dying, even in common law systems. We mostly only use them now for criminal cases, and even then not all criminal cases. As far as I know, the only country now that uses juries in civil cases, like personal injuries, is the US. And only in some states. In other states, they don't use juries. The judge will decide. So, okay. So to sum up, Roman law thinking is structured and codified. Common law is case-based, principles-oriented, pragmatic, but pragmatism nowadays dictates that we also have certainty. So that's basically it. Anybody have any comments, any observations about the two systems? Any questions? Any comments? Questions?
It has been quite clear, the entire presentation, Mike. I think it has helped us a lot to understand the difference between both systems, and also to learn about vocabulary and applicable rules, which is something that's so useful for us.
Well, if anybody has any questions, please feel free to ask me. I will be very happy to answer any questions that anybody has. You can either copy this. I should have put a QR code. I didn't. I should have. I have one somewhere. Or mycatskillsbar.eu. But anyway, Natalia, if you don't mind, please forward. Anyway, I think I'm in the group, so I'll give my details anyway. Or you can just contact me in the group via WhatsApp. If you do that, that'll get me anyway. So just feel free to ask me any questions via WhatsApp, and I will do my very best to answer. Pleasure meeting you all, and I hope we meet again. In fact, next week I will be doing a shorter presentation. It'll be more like 1 hour, and it'll be a more technical one from the language point of view. It's basically false friends in legal English, where terms that we use in common law systems in the Anglo-Saxon world do not necessarily mean the same thing in most of the countries that use Roman law, which are not native English speaking. So it's more of a sample presentation, because there are many, but I will run through a sample of different false friends that we come across, and ones that we need to be particularly attentive to, because if we're not, they can cause problems. And I'm speaking from experience, because when I came to Romania about just over 20 years ago, I made many dangerous and quite stupid assumptions, and I was proved painfully wrong, like the issue of the contract versus the pre-contract. What I was referring to as a contract of sale, they thought I was referring to as a deed of transfer. But I learned pretty quickly, because once I started teaching legal English, that became my business to learn the differences. But when I came here first, yeah, there were a lot of very, very serious traps that a person could easily fall into. Yeah, and I fell into a few of them myself. So yeah, I will take a look at those next week.
Thank you so
Any
much,
comments?
Mike.
I see we're just
Thank you.
approaching 2 p.m. there, I think. So we'll wrap up. If you have any comments, any questions, like I said, WhatsApp me.
Of course, and we will be
Hello,
happy to
Mike.
meet you next week, okay?
Absolutely.
Say
I'm looking
something.
forward to doing it. Thank you all for coming here. And I hope you
Thank
managed
you
to get
very
it all
much.
recorded, Natalia. Yeah, to
Muchísimas gracias.
Chao, buenas noches,
Chao, buenas
gracias.
noches.
Chao, gracias.